Duty. A duty is an obligatory act. It is an act opposite of which would be wrong. By Salmond. A duty is an act which one ought to do, an act the non-performance of which will be wrong. To ascribe a duty to a man is to claim that he ought to perform certain acts. Duty means a human action which is in conformity with the law which requires us to obey them. In its use in jurisprudence, the word duty is the correlative of right. Thus, whenever there exists a right in one person, there also rests a corresponding duty upon some person or upon all persons generally. As a technical term of the law, duty signifies a thing due, that which is due from a person, that which a person owes to another. Commonly speaking, duty is an obligation to do a thing. Where the law recognizes an act as a duty, it commonly enforces the performance of it or punishes the disregard of it. Duty may be positive or negative. Positive duty is when a person is obliged by law to do an act, and negative when one has to abstain or forbear from doing an act. Duty can be primary and secondary. Primary duty stands independent of any duty, whereas secondary duties exist for the enforcement of some other duties. The duty of a person not to injure anyone is a primary duty, but to pay compensation if he has injured someone is a secondary duty. Duties and right are correlated. According to Salmond, there can be no duty without a right. According to Austin, some duties are absolute. There have no corresponding right. Absolute duty can be enforced criminally. Duty is not to kill anyone, but if a person commits suicide, the law shall punish him. A duty may be moral or legal. A moral duty is that class of moral obligation which lies outside the legal sphere but depends on ethics. They have not been recognized by law for the purpose of their enforcement or redress. Legal duty, on the other hand, is the obligation arises from contract between the parties or the operation of law and is therefore enforceable.